What employers don't want you to know if you get hurt at work. When you report a work accident, your employer might try to sell you on the idea of going to an urgent care provider. After all, urgent care providers have many locations and probably one that's close to you. And you can just walk in without needing to call ahead. All sounds good. But here's the downside. Urgent care doctors provide fast care, not necessarily the best care. They usually don't have specialty training, and they're also not equipped to run the kind of tests necessary to see if you've broken or fractured any bones, such as MRIs or CT scans. Urgent care doctors are also more likely to rush you back to work, even if you're still injured and in need of additional medical treatment. The truth is, the quality of your medical care can make or break a workers' compensation claim. Your employer may not want you to know all your medical treatment options, including your right to see an orthopedic specialist as soon as possible. No referrals needed. If you want to see an orthopedic specialist following a work accident, Georgia law says that's your choice, and it's your employer's job to assist you in arranging an initial appointment. So, if after you report a work accident, your employer tries to force you to go to an urgent care provider or tells you that's the only option available, well, that's illegal. And you need to call the injury attorneys at Morrison Hughes. We'll make sure you understand your rights and get the benefits you deserve. Your employer might not want you to know that when you report a work injury, you have to mention every single body part involved. Here's a fact pattern inspired by one of my cases. Let's say you fall from a ladder onto a concrete floor at work and land directly on your back. You scream out loud at the time, "My back! My back!" And you're taken from the scene by ambulance to a nearby hospital. You only talk about your back with paramedics. You only talk about your back with the doctors at the hospital and also with your employer. Now, you knew at the time that your neck was also hurting, but not as much as your back, and so you waited longer than you should have to talk about that with doctors. Now, even if you need surgery on your low back and probably your neck as well, the work comp insurance company tries to deny coverage for the neck because they say that body part was left out from all the initial documentation. Bottom line, when you report a work accident, don't just focus on what hurts most. Focus on every body part that hurts and mention every body part. Also, if it's your back, are we talking about your upper back, your mid back, your low back? Yes, it's necessary to be that specific because doing so might help you avoid a frustrating coverage dispute later. So if it seems like work comp doctors are paying attention to some of the body parts involved in your work injury, but ignoring others, well, it's probably time to call the injury attorneys at Morrison Hughes. We'll make sure you get all the medical care you need after your work accident. When you report an accident at work, you'll need to tell your employer when the accident happened, how it happened, if there were any witnesses, and what you believe your injuries are. Your employer then has the responsibility of informing their work comp insurance carrier, who then assigns this person, called an adjuster, to the claim. That insurance adjuster may then reach out to you and ask for a recorded statement. Employers don't want you to know there's no requirement for you to give a recorded statement to their insurance company. When insurance adjusters ask injured employees to give recorded statements, they won't tell you what information the employer already shared with them, or if their goal is to deny all or part of your claim. Remember, your employer's work comp insurance carrier and the lawyers they have working for them are there to protect and defend the employer's interests, not yours. If you're being asked to give a recorded statement about your work accident to your employer's insurance company, speak with a Morrison Hughes injury attorney first. If you've had a work injury, it's common sense that you should report it right away to your employer. But what does it mean to report an injury right away? A work injury might be a sudden event, such as falling off a ladder onto a concrete floor, or it might be something a lot less dramatic. You might suspect something you're doing at work is causing pain, but maybe you think it will go away with a good night's rest, and you don't say anything about it at first. After a few days or a few weeks go by, that pain gets worse, and now you finally do report it to your employer. You know what? That's okay. Employers don't want you to know that under Georgia law, you have a full 30 days to report a work accident. And generally, you also have a full year from the date a work accident happens to file a workers' compensation claim. So if your employer tells you that work comp benefits are not available because you waited too long to report an injury, don't just take their word for it. Call the injury attorneys at Morrison Hughes. If you've been seriously hurt at work, chances are you're treating with one or two or possibly even several work comp doctors. At any given time, one or more of those doctors might assign work restrictions. For instance, no lifting more than 10 pounds, or no reaching overhead with your right arm. Whatever restrictions your work comp doctors assign, it's important to make sure your employer is on the same page. If your doctors give you a work status form each time you have an appointment, it's a good idea to turn in a copy of those forms to your direct supervisor. Your employer has specific responsibilities in handling your work restrictions, which they might not want you to know about. Now, they can either accommodate your restrictions, which means not making you do anything at work that your doctors don't want you doing, or they can tell you they can't accommodate your restrictions, which means you're entitled to start getting weekly workers' compensation income benefits. So remember, if your employer knows about your work restrictions, but tells you you're still required to do your regular duty job, well, that's illegal. And you need to call the injury attorneys at Morrison & Hughes, and we won't